So welcome everyone to the 8th tutorial for LAWS12070 on public, international, and human rights law. And tonight, our topic will be on international humanitarian law. That particular topic may seem quite familiar to many of you because you've probably heard often said in the news, the suggestion that a lot of states right now are facing a humanitarian crisis. And the humanitarian crisis that we would have heard not only goes back to what had happened in Africa, where there was a lot of starvation and issues about in the 1980s. I was just watching a video again about the Live AIDS concert when I was watching Bohemian Rhapsody by Queen, and we get reminded that issues about humanitarian crisis have been happening even in recent times. And this particular topic has again emerged. Mainly for two reasons. In Australia, for example, in the public discourse, we talk about suggestions that Australia appears to be violating some norm of international law by its failure to act humanely in relation to both refugees, who we know, a lot of whom are actually fleeing war-torn countries, such as Afghanistan, Syria, and Iraq. And in fact, a lot of these refugees have been, relocated in Australia. So there seems to be a humanitarian crisis going on, at least in relation to Australia, and for the Australian government to turn back these boats, which was, I think, the policy of the current government and the past governments as well, including that of Peter Dutton and even the current Prime Minister when he used to be the Minister for Immigration. There was that policy of turning back boat refugees. And suggestions were made that Australia is failing in its obligations to provide humanitarian assistance and might be violating international humanitarian law. And we begin to wonder, is there in fact such an obligation on the part of Australia in relation to international humanitarian law to provide some sort of assistance or to perhaps to deal more humanely with both refugees? And the same problem is faced by the United States of America right now, and even Mexico, in relation to the caravan of political refugees coming from, states such as Paraguay, Uruguay, and so on, where there is war, where there are armed conflicts going on. And you would have come across news, very, very harrowing news images last year of a child that had drowned in some Mediterranean waters, trying to flee with her family, as well as thousands of other refugees from war-torn states such as Syria, Iraq, and other places there, and trying to flee to Greece and Turkey and so on. And the issue that has always arisen is whether or not there is an international law obligation on the part of the states to provide some assistance to these refugees, and whether or not the failure on the part of states to extend some assistance and perhaps to act humanely in relation to these refugees might be a violation of international law. So that's one aspect of the topic on international humanitarian law. The other question we ask would be, we would have come across stories, especially a few years back, of the United States seemingly using torture to elicit very important information from so-called terrorists, jihadists, and members of Al-Qaeda. And they were doing this in Guantanamo Bay. And for the moment, let's assume that we're not dealing with torture, but in relation, for example, to terrorists, would a state have an obligation to deal with them under international humanitarian law? Or would the fact that a state is dealing with terrorists mean that these terrorists are then beyond the purview of international humanitarian law? And how do we distinguish, in fact, between torture and international humanitarian law? Would it mean that when a state uses torture, a state might be torturing terrorists, prisoners of war, and so on? Would it be committing a breach of international humanitarian law? Or would it be breaching perhaps a convention law, such as the United Nations Convention Against Torture? And so therefore, where exactly is the distinction between international humanitarian law and the law, international law against torture. Going back to the issue of terrorists, for example, we begin to ask whether or not, if a terrorist is captured, whether or not there is an obligation on the part of a state that has captured a terrorist to accord such a terrorist the rules of international humanitarian law so that that terrorist should be considered a prisoner of war. So these are some of the questions we ask. We can also ask questions about local armed rebels, because we know that armed conflicts are going on in various parts of the world. It's happening in the Philippines, it's happening in Indonesia, it's happening in South America, and it's happening in a lot of other countries where there are ongoing armed rebellion from local forces. And in that particular case, do the rules of international humanitarian law apply? And so there is a lot of relevance to the discussion about international humanitarian law in the context of what is happening today. So tonight, after studying this topic, you should be able to discuss and explain the principles of international humanitarian law and the key provisions of the Geneva Conventions relating to armed conflict. And I have prepared 7 questions. Very good. Now, before I continue, before we proceed, would any of you have a question or comments? So we're all good. We could continue. So we're going to go through the 7 discussion questions I've prepared for tonight. And we begin by looking at the quiz question, which encapsulates a lot of the key principles on international humanitarian law. And in the event you happen to have any question that may not have been covered in our discussion questions, please feel free to raise that issue in the course of our tutorial. Can I get a volunteer to read question 1 for us? And remember, this is the quiz question. Can I get somebody to read question 1?
I'll read it, Manjo.
Thank you, Dean.
New Kenya has for some time been facing an armed rebellion from the Finland freedom fighters, a local rebel group which has used ruthless means to attain the goal of setting up an independent state. Deciding that enough is enough, New Kenya has decided to use the full powers of the state to quash the rebellion, including the use of torture, ill treatment of wounded captured rebels and their relatives, and destruction of rebels' homes. Which of the following statements is the most correct answer? A. Do you want me to read that or not?
Yes, please. Please read it.
A. New Kenya is in breach of the international humanitarian law. B. New Kenya is not in breach of international humanitarian law. C. New Kenya is in breach of international customary law, prohibiting the use of torture. D. The use of torture against the FFF is a breach of international humanitarian law. Or E. All the answers are wrong.
Okay, thank you, Dean. Now, can I ask everyone to try to attempt to answer the quiz questions by posting your answers in the chat box, by choosing one of the letters there among the choices. And then we will take it from there. So we've got A, so a lot of, but 2 answering A, 2 answering C, 1 answering D. Okay, Heidi, C. From Dean, we've got B, seems to be the lone dissenter. Has everybody answered? Am I getting an answer from Peter? From Clinton, letter B as well. Peter, do you have an answer for us? And from Tony as well. So from Peter, it's letter D. How about Tony? Okay. Okay. So a majority of the students are answering C or D. Can we have a discussion as to your answers? And if you could just explain why you think your answer is the most correct one.
I'll go there, Manjo.
Okay, thank you, Peter. So you've answered letter D. Okay.
Yep. I've hit D because it's an internal thing. It's not a an external war or conflict. It doesn't sort of come under the international rules of for war. However, or international conflicts. However, it does breach the international humanitarian laws regarding the torture, and that's what I believed anyway.
Okay, let's examine that, because there are two things. You said that you had said, one, that it's an internal conflict, therefore it can't be covered by international humanitarian law. But at the same time, you were suggesting that there is a possibility of a breach of international humanitarian law because of the use of torture. So does international humanitarian law apply or not? That's essentially the question. From Emma, for example, she's making the case that there is customary international law against the use of torture. Because it is a local rebellion, it is not under the international humanitarian law, but under international criminal law, ICL. The question we ask is this, okay? This is the question we need to ask. When we speak of international humanitarian law, does international humanitarian law apply only to international armed conflict? Or does it apply as well to non-international armed conflict? In other words, when you can have a local armed conflict or a domestic armed conflict, can international humanitarian law apply? That's, okay, so from Emma, she says it can be non-international, and that's correct. We assume here from Ilionka, is this an armed conflict? We assume that there is an armed conflict going on. So we make the assumption that there is an armed conflict because we indicated here that they have been facing an armed rebellion. So there has to be an armed conflict. We would have to assume that. Okay. And so the proper answer, well, the proper principle to remember is that international humanitarian law applies both to international as well as non-international armed conflict. Now, we're going to get into the details in a short while. So we assume that any captives are POWs, or prisoners of war. I'm not sure. Okay. So Ilionka, in asking that question, what were you trying to raise?
All right. So my understanding of this international humanitarian law is it's in time of conflict. You need to determine what the type of conflict is to see whether it's international humanitarian law that applies, and then whether it is the conventions. The Geneva Conventions are then basically divided into international conflict and non-international conflict. And then there's customary international law that comes up that basically applies to anything that's classed as an armed conflict. But it's not very clear what the threshold for an armed conflict is. That's why I asked the question whether we take it, because they're freedom fighters. And some of the case law, basically, it comes across that, I think one of the comments was that it doesn't matter how intense the fighting is, how many lives are lost, you need to consider the proportionality and all that sort of thing. So from, I don't know, my understanding of the question is that these guys are freedom fighters, so it's not really an armed conflict for the purposes of falling under international humanitarian law, but there are customary laws that prohibits the use of torture specifically. So that's why I chose C. That's, yeah.
Okay, let's address that issue first about, because Ilionka correctly pointed out, the issue about the extent of the armed conflict, and when is it suggested that armed conflict takes place? Does it matter as to the number of people who are killed and so on? Now, the crucial point is that if you're dealing with, and I wonder if I'll be going to the answer in a short while, the crucial point is that if you're dealing with an international armed conflict, it doesn't matter as to the level of armed conflict going on. The fact that you have an armed conflict between two states, international humanitarian law necessarily will have to apply. But as we see shortly, if what we deal with is a non-international armed conflict, the rules are in fact different. So I'm not going to proceed yet because I'd like to hear the answers of the others. So we make a distinction between in terms of the level or the extent of the armed conflict, if it's an international armed conflict as opposed to a non-international armed conflict. Because if it is an international armed conflict, automatically, if it's international, meaning occurring between two states, or the agents of a state and another state, or even an agent of a state and another state, such as what had happened in the case of Nicaragua versus United States of America, international humanitarian law applies straight away. Now, if it is a non-international, meaning it's a domestic armed conflict, the rules are a bit different, and we're going to discuss that in a short while as we go through the different answers. Now, the second point that Ilyonka importantly raised was the issue of time, the temporality of the armed conflict, and whether or not the rules of international humanitarian law apply only during the period of armed conflict. And would it mean that the rules of international humanitarian law no longer apply the moment that the so-called armed conflict has stopped? And that has actually been answered in the case of Prosecutor versus Tadic, where the International Criminal Tribunal, an international tribunal that was set up by the United Nations Security Council, where the ICT ruled that as far as temporality, as far as the time frame is concerned, it doesn't mean that international humanitarian law will cease the moment that the armed conflict will stop. Because even if the armed conflict can stop, it is possible that you can have prisoners of war. It is possible that you can have civilians who are, casualties of war. You can have wounded soldiers. You can have civilians who are trapped, or who are suffering as a result of the armed conflict. So the case of Prosecutor versus Tadic was quite clear that the rules of international humanitarian law will continue to apply even after the cessation of the armed conflict. Okay, so now let me just go through the others. And I'm going to go back to the rule on torture in a short while. Okay, so from PETA, it does not apply to internal disturbances occurring in the territory of the high contracting parties. Okay, that is not very accurate, because as far as international humanitarian law is concerned, in the Geneva Conventions, in fact, when you examine the phraseology of the 4 Geneva Conventions, international humanitarian law does apply not only to international armed conflict, but also to non-international armed conflict. Now, Ilyonka is correct in pointing out that in the context of riots and uprising, it doesn't necessarily follow that you have an armed conflict. And that's the reason why you make a distinction between international versus non-international armed conflict, because, okay, I'm gonna have to provide the answer now, because, as I said, when we deal with an international armed conflict between states, automatically international humanitarian law applies. But when it comes to non-international armed conflict, the requirement seems to be that there has to be protracted, large-scale armed conflict between the state and a dissident group. The other reason for the other requirement as well, one of the other important attributes when the international humanitarian law will apply is when the dissident group is actually has an army of its own that is capable of strongly opposing an existing state, but at the same time they are in a position to actually have de facto civilian control of a particular territory. So if what you have would be sporadic attacks, international humanitarian law will not apply. But if you have, for example, when you examine the case of Sri Lanka, and of course we're talking of the Tiger freedom fighters in Sri Lanka, to the south of Sri Lanka, the Tamil freedom fighters were actually in control of that particular territory of Sri Lanka. There are also parts, I think, of Somalia and Sudan where there are areas or territories controlled by an armed group, by an armed rebel group. So in that case, you not only do you have an army, you also have a de facto civilian government controlled by an armed rebel group. In that case, international humanitarian law will apply, regardless of whether or not there is actually consent on the part of the rebel group. The point being that when you have these types of non-international armed conflict, the rules of international humanitarian law are meant to apply as part of customary international law, not only in order to protect civilians, but also prisoners of war, as well as those who are wounded in the course of battle. But what if what you have would be, you know, some kind of a rebel group, which is happening in the Philippines, for example, or parts of Indonesia? In relation to these rebel groups, international humanitarian law will not apply. Any questions so far on that point? We're clear? So the requirement so let me just clarify again. If you have an international armed conflict, it doesn't matter as to the nature of the armed conflict, automatically, or the level of the extent or enormity of the armed conflict, automatically international humanitarian law applies. But if you're dealing with a non-international armed conflict, in other words, it's domestic, you probably have an local armed rebel group or a dissident group trying to, you know, overthrow or attack an existing de facto or legitimate government. There has to be a requirement that there is a standing army for the dissident group. They have de facto civilian control of parts of the territory, and therefore they have an ability to follow the rules of international humanitarian law concerning prisoners of war, the wounded soldiers, as well as civilians. So we're clear. Now, the other question that needs to be raised is in relation to torture, the use of torture. Okay, there is no customary international law against torture. There is none. We do have convention law. So you have the United Nations Convention Against Torture. It hasn't become customary international law, mainly because you can have a problem about the definition of torture. What exactly is torture? And you have a lot of states, including the United States and Israel, putting reservations as to how torture should be defined. And they've also made reservations as to when they are willing to accept a judicial determination by international courts as to the definition of torture. And because of the theme about prohibition of torture is kind of more recent than the issues of war, we cannot speak at the moment of torture as being part of customary international humanitarian law. Now, we make a distinction between torture and genocide, or torture against acts against humanity. These are different things, because you can always say that when a state is committing genocide, or when an armed group is committing genocide, they can use torture. It's possible they don't. But genocide by itself is different, as we see when we discuss it in week 9, because you can only have genocide when there is an attempt to exterminate a class of individuals. And when you speak of crimes against humanity, you're again speaking of wide-scale, large-scale killings or crimes against particular persons. So the use of torture on its own, okay, cannot be a breach of customary international law, because there is no customary international law relating to torture. Okay, now, so in relation to letter D, the use of torture against the Fineland freedom fighters is a breach of international humanitarian law. If we say that international humanitarian law does not apply in relation to question 1, because the armed rebellion does not attract the application of international humanitarian law because it's just an armed rebellion, then in that case, the use of torture cannot be said to be a breach of international law, simply because international humanitarian law, simply because international humanitarian law will not apply in the circumstances. So the correct answer should be New Kenya is not in breach of international humanitarian law. Now, an important point to remember again is that one of the main attributes of a state is the right to sovereignty. It's an essential attribute of a state. A state has an important attribute of sovereignty, and that means that that state has plenary power of what goes on within its territory, including, as you recall, prescriptive jurisdiction, which involves the power to make laws. And so therefore, you see, instances when a state may be using torture. It's happening in Saudi Arabia. It's happening in a lot of other states. Are they in breach of international humanitarian law? The answer is no. They can potentially be in breach of the United Nations Convention Against Torture if they did not make any reservations and they are a party to the convention. But what it essentially means is that because of the principle of sovereignty, a state is generally free to do what it likes, including hanging, including putting people in the electric chair. Some will probably argue that the act of killing people, prisoners, hardened criminals, through lethal injection is a form of torture, because, or even electrocution on the electric chair, because you have seen instances when people or prisoners have been on the electric chair for several minutes, or people suffering, not being treated humanely when they are given a lethal injection. Okay, questions so far? Okay. So we have here from Ilioka, the prohibition of torture and other cruel or inhuman treatment and outrages upon personal dignity, in particular humiliating and degrading treatment, is recognized as customary rule in the is this the International Red Cross? ICRC studies customary international humanitarian law, and by the International Criminal Tribunal for the former Yugoslavia. Okay, so what we need to remember again is that as far as the International Red Cross, which has been very active in helping shape international humanitarian law, what we need to remember is that it is evolving. And we also need to remember that as far as international law is concerned, it is created not by the Red Cross, because if you recall the sources of international law, the sources of international law would be the consent of states through convention. It could be customary international law, meaning the consistent practice of states, where the consistent practice will evince or demonstrate opinio juris, or the understanding that what they're doing is part of a legal obligation. And the third would be general principles of international law. So in other words, the International Red Cross on its own does not create international law. Not even the United Nations does. It doesn't. Okay. So there is a view that torture should at some point evolve into customary international law, but that's difficult, mainly because it's difficult to determine what exactly is torture. Okay. Now, but we need to remember, however, that the use of torture, can cut across many ways, because, as we said, the use of torture can violate international conventions, such as the United Nations Convention Against Torture. It can also violate international criminal law if it becomes, there are crimes against humanity. There will also be potential violations of international human rights law. Okay, but for our purposes, what is crucial to remember is that at this point, what we have is international convention law against torture, but there is still no customary international law, simply because there is no consistent state practice in relation to the prohibition against torture, mainly because a lot of states are still unclear as to what they're willing to consider to be torture. And so some of them continue to use what might be considered to be torture, which includes, for example, sleep deprivation, putting prisoners incommunicado for a while, or putting them in solitary confinement. Would that be torture? So because of that reason, because of the inability, the difficulty in trying to pin down what exactly is consistent state practice, which is a crucial element for customary international law to evolve, it's difficult at this point to speak of customary international law against torture. And that's the reason why it's important for a state to be bound in relation to the rule against torture. They need to sign the convention, because otherwise there is no customary international law against torture. Okay, questions? So we know what the answer now is in relation to question 1. So we're clear. Question 2. Let me just read this. This is quite short. The United States of America, through its Central Intelligence Agency operatives, was alleged to have tortured many alleged Al-Qaeda terrorist and jihadist prisoners in order to secure information from them about the whereabouts of Osama bin Laden and his top lieutenants, as well as about the plans of Al-Qaeda. I hope you're familiar with Al-Qaeda, right? You should be. Did it commit a breach of international humanitarian law in using torture? From Dean, the answer is no. Okay. The answer is no, because there is no customary international law in relation to torture. But the crucial point here is, why isn't there a breach of international humanitarian law? Assuming it wasn't torture, it was, treating them inhumanely or whatever. Doesn't international humanitarian law apply in relation to the acts of the United States and its dealings with terrorists?
No, it doesn't, Manjo.
Why not?
Because these terrorists, they don't come under combatants, basically, under non-international or international conflict. It's not considered an armed conflict. I think there was a, where was it now? There was something about that. Yeah, I'll find it for you in a sec. Yeah, from Natasha Balendra. She said the underlying argument is that to be considered an armed conflict under international law, the conflict must fall within the parameters of either an international or non-international armed conflict, and that a conflict with Al-Qaeda doesn't fall into either category. And then also in our textbook, he made a similar comment that, and it made a good bit of reasoning too. He said that, or somewhere it said that they can't really, they haven't agreed to abide by these international norms, so they can't be expecting to get the benefits of it via the Geneva Convention or such.
Fantastic answer, Dean. We also have comments from Emma. There is no international humanitarian law does not apply against terrorist organizations because they don't fight within a territory. In fact, if you notice terrorists, what terrorists typically do is that they stay in a particular base, say in Afghanistan or Pakistan, and then they launch terrorist attacks in countries such as the US or Yemen or whatever. Okay, so in that part, and of course, they therefore don't have the ability to control its own army against a sovereign state, nor do they have de facto control, because how terrorists do it is that they keep on moving around. Okay, and so the crucial point as well, as Pita has pointed out, is that it is part of state sovereignty to be able to deal, for a state to be able to deal on its own with terrorists. And so you will notice that what will typically happen, such as Turkey today, is that Turkey is attempting to frame the international discourse that the Kurdish freedom fighters, are you familiar with this? That the Kurdish freedom fighters are a terrorist group. Remember, this is a very important issue because 2 weeks ago, prior to the new year, the US President Donald Trump issued a public statement that the United States was going to pull out of Syria as well as Iraq. And the net effect of, and they were going to be, they were to stop providing support even to the Kurdish armed, Kurdish freedom fighters. But the Kurdish freedom fighters had actually taken the side of the United States and its allies in the war against Bashar Assad. But because of the decision of the United States to pull out of Syria, what it would have meant was that the Syrian freedom, the Kurdish freedom fighters operating within the border of Syria and Turkey would lose the protection of the United States military. Now, what Turkey has done is to say that the Kurdish freedom fighters are a terrorist group. In doing so, what is the effect? Why is Turkey saying that the Kurdish freedom fighters, even though the Kurdish freedom fighters actually control a sizable portion of Turkey? It does. Turkey can't go there. It's because there's a protection for the United States. So the reason for that's correctly pointed by Emma is that if a state says that a group, an armed group, is a terrorist group, international humanitarian law will not apply. And so therefore a state will not be in breach of international law by dealing with a terror group in whatever way it likes. So as pointed out by PETA, it becomes open season. So that's the way they would do it. They would label an armed group as a terrorist group so that international humanitarian law will not apply. Now from Clinton, Guantanamo was more of a last holding place. A lot of the question was conducted in other countries before they arrived at Guantanamo. Indeed, yeah, so. So as far as terrorists are concerned, international humanitarian law will not apply. Very good, okay. So let's look at this question. Do the Geneva Conventions impose legal obligations on Syria to protect its own nationals in the ongoing Syrian war, the war in Syria? Hopefully you're familiar with what's going on in Syria, right? Do the Geneva Conventions impose legal obligations on Syria to protect its own nationals in the ongoing civil war? You have to think about this carefully, though, because there are two aspects to the question, okay? One, is there an international armed conflict in Syria? The second question is there a non-international armed conflict in Syria? Because if either of those conditions apply, then international humanitarian law will have to come in. So when you examine the case of Syria, there is a war against the government of Bashar Assad, conducted by the United States, United States, Turkey, Saudi Arabia, and I think even Australia. There is an international armed conflict going on. And for that reason, international humanitarian law does apply. Now, in relation to the non-international armed conflict, if you look at the facts, we know that there are armed groups that do control sizable parts of Syrian territory. And there have been, constant attacks and counterattacks in those areas, so that after a while, it's the Bashir government controlling the territory. After a while, again, it's the local armed group. So if these events apply, meaning there's an international armed conflict and or there is a non-international armed conflict, then international humanitarian law will apply, and therefore it means that all the states and even the local armed groups that control a sizable territory have an obligation under the Geneva Convention, as well as particularly in relation to customary international law, to protect nationals in the ongoing Syrian war. Okay? Now, in relation to this war against local groups, you make a distinction between local groups, the local armed groups which control portions of the territory. International humanitarian law will apply because you have an armed dissident group that has a de facto government in these areas, versus ISIS and ISIL, which are just terrorist groups. They don't have control of a particular territory, but in fact what they do is to send out armed groups in other states. Questions so far? Correct. So from Dean, in relation to our civilians, the first are those who are at a given moment and in any manner whatsoever find themselves in case of a conflict or occupation in the hands of a party to the conflict of which they are not national. So it could be that you have the United States government ending up in having some kind of form of control over certain civilians. The second type of civilians are those who at a given moment and in any manner whatsoever find themselves in case of a conflict or occupation in the hands of an occupying power of which they are not nationals. Okay, very good.
Manjo?
Yes, Dean.
Sorry, the way I read that question, I thought it was asking whether the Syrian government is under the Geneva Convention obligations to protect their own nationals. And the Geneva Convention doesn't apply to one's own nationals. It's only someone else's nationals. So that's what I was getting at. So, the US, they have to treat the civilians because they're not their nationals. But basically, Syria can do whatever it wants to its own nationals, but it can't do it to other people's nationals.
I think you're correct there. I think, I did miss that, Dean. So thank you for pointing that out. That was I just assume that, you know, there is an obligation on the part of Syria because there is an international humanitarian law that applies. But in fact, as correctly pointed out by Dean, international humanitarian law might apply in relation to Syria and, you know, prisoners of war, but not in relation to its own civilians. So I stand corrected. Very good. Very good. So thank you, Dean. You're correct. So there, in relation to civilians, and I'm glad that you pointed that out because I may have glossed over that. In relation to an obligation of a state, when it comes to its own nationals, it doesn't trigger an obligation under international humanitarian law. It has the civilians can only be in relation to the nationals that do not belong to the state. Very good. Thank you, Dean, for pointing that out. Any questions? Okay, fantastic. Very good. Okay, question 4. I'm just going to read this. It's a short question anyway. You might remember that during the Iraq Gulf War, the Iraqi regime of the late Saddam Hussein would often display prisoners of war on television in a humiliating way. They would also often be made to confess to crimes or to criticize their own government. Do you think those would constitute a breach of international humanitarian law? Very good. So the answer is yes. That's a clear example of a breach of international humanitarian law. Sometimes, though, a crucial point we need to think is the issue of enforcement, right? When it comes to a state, you can always complain. There's always a venue for complaint in the United Nations. And if it's an international armed conflict, it could be a state complaining against another state involved in an armed conflict with the International Court of Justice. A complaint may also be brought before the United Nations Security Council. But the bigger question actually is, if we say that in relation to a non-international armed conflict, and you have a local armed rebellion going on, a local armed dissident group, which is able to control a sizable portion of the territory, which has its own army and has a kind of a de facto civilian government, the question is, how exactly will you be able to apply or enforce international humanitarian law to the local armed group? What do you think? What do you think? Because we said, I mean, did you get my point? Was that clear? Okay, so let me repeat the point. Let's assume that international humanitarian law will apply in the case of a local armed group that is, in an armed conflict with a particular legitimate or legal or de facto government, and that local armed group has its own army and has a de facto control of a portion of the state's territory. So we assume, therefore, that international humanitarian law will apply in relation to that local armed group. My question is, how exactly will you enforce international humanitarian law against a local armed group when they're not a state? You can't go to the United Nations because the local armed group is not a subject of international law. So from Peter, with great difficulty. Okay, indeed. How else? And the answer, yes, Dean.
I would say it would be near impossible. I mean, if the legitimate government can't even put these people down, what chance is some other country going to have to do anything?
That's right.
It's pretty much, you're blowing into the wind. It's not going to make a lot of difference. You may get the moral high ground, but you're certainly not going to achieve any real result.
True. Not easy.
The only way that they'd have a hope in Hades, I'd say, would be to do a Noriega on them, go and kidnap them.
Yeah, that's right. So there are, in fact, two ways of enforcement. One is through the United Nations Security Council, as had happened in the case of Prosecutor versus Tadic. Tadic was part of a a Serbian group which had perpetrated atrocities during the Balkan Wars. It was eventually captured by the United Nations armed forces then. And because the United Nations Security Council had intervened, the United Nations Security Council created the International Criminal Tribunal. And that's when they ended up prosecuting and then eventually subjecting Tadic to punishment. But it took years, you're right. So that's happening as well in some parts of Africa where there are local armed groups going on who have been captured by United Nations, I don't know how you call them, peacekeeping forces. That's one. But the second aspect is sometimes some of these local rebel groups end up becoming the legitimate government. They overthrow an existing government. So if you look at Cuba, if you look at Fidel Castro was able to topple the government of whoever that was. Can't remember now. Or you could have some local group again toppling a legitimate government. In that particular case, you would have clearly you'd be able to identify who the previous local rebel now is, who may have committed violations of international humanitarian law, and therefore it would be possible for those leaders of states then to have to account for their activities as a result of a breach of international humanitarian law. But it is not easy. And in fact, the other point we can make is that even if a state is in breach of international humanitarian law, and you might say that the United States government and its officials might be in breach of international humanitarian law, but how exactly are you going to enforce punitive measures coming from the United Nations, right? You can't simply arrest Donald Trump or former President George Bush. You can't do that. Okay, but the issue of enforcement is altogether different, because if you have the biggest guns, so like if you observe what's happening in Russia with Vladimir Putin, it's possible that Vladimir Putin and Russia is responsible for breaches of international humanitarian law, but they're able to get away with it because they've got the guns.
Well, just look at Crimea.
Yeah.
They just walked in and took it.
Indeed.
Nobody can do anything about it.
Exactly, because not even the United Nations Security Council can do anything because of the veto powers of Russia. So,
Manjo,
yes,
you're talking about that business with Slobodan Milosevic and Radovan Karadzic and how they had the International Criminal Court against those men.
Yes.
And I think from memory, I just put it in the chat there, I think that was from the Srebrenica massacre that they had. But from what I remember, it was only once, particularly the president was no longer the president, they could do anything about him anyway. And then, and he had to be surrendered by the Serbian authorities anyway. Like, it wasn't like they could just go and get him.
Yeah.
They had to agree to let him go.
That's right.
So it's still like dodgy, isn't it? Like,
yeah, he was being protected. Okay, questions? So we can go on. Question 5. Okay. Can prisoners of war be tortured or coerced, perhaps by using waterboarding or using electric shocks, in order to secure critical military information that they might possess? Yeah, very good from Dean as well. Okay, so if we speak of a prisoner of war and we assume that this is a prisoner of war coming from, these are the soldiers of an enemy state, or they're the soldiers of a big local dissident group, so therefore international humanitarian law will apply. In that case, waterboarding or electric shocks would not be permitted. But how about in relation to terrorists of Al-Qaeda and ISIS who might be captured? Yeah, but they're not prisoners of war, which is the reason why you will notice that there is often an attempt to get these terrorists to be considered prisoners of war. Because then, if they're considered prisoners of war, the state that has captured them have an obligation in international law to obey the rules of international humanitarian law. Okay. So from Clinton, terrorist same conventions, protections do not apply. Yeah, so international humanitarian law doesn't apply to terrorists. And terrorists in the first place do not care about the international humanitarian law. Right? They don't. Okay. Question 6. Yeah, from Dean, hypocrites. Yeah. Question 6. Does international humanitarian law impose illegal obligations on states, such as Australia, to act humanely towards both refugees and political refugees? Because you keep on hearing it, right? There is an obligation on the part of states in a humanitarian crisis to assist, refugees and so on. And the answer is no. Yes, Peter?
I think you've got to look at it from the point of view of where these people are fleeing from.
Yeah. And
where their first port of call is. That first port of call has I think has a duty of, moral duty, if nothing else.
Yeah.
To look after them. But when they've sort of been in 3 different places and they've fled from 3 or 4 different places, and that duty of care is sort of way down the track. It's back further. So I don't think that we have the obligation that is trying to be put on us by many people.
Correct. We go back to what Dean had pointed out earlier about civilians in relation to the Geneva Conventions on the protection of civilians during war. And as correctly pointed out by Dean there, when you speak of civilians, we're talking of civilians who are under the control of an occupying state. And obviously, Australia can't be the occupying state. So the Geneva Convention certainly cannot apply. From Ilonka, should they not then be prisoners of war, since the process in place is to determine the identity? Okay, I'm not familiar with the Martin's Clause. But when you speak of prisoners of war, we're simply assuming that you're dealing with soldiers, and you're assuming that international humanitarian law will apply. But again, the international humanitarian law will only impose an obligation on a state that is part of that armed conflict. There is no international humanitarian law will not apply to a state that is not party to the armed conflict.
Manjo, can I ask another question? Here's a curly one. So, okay, case scenario, you've got Australia, at least in the past, involved in Iraq. Assuming, of course, that could be categorized as an international armed conflict. If an Iraqi citizen was to find themselves in Australian hands
in Iraq,
would it have to be in Iraq, or could it be on a boat somewhere on the high seas? Wouldn't that 4th convention apply then as well? Because it doesn't say. It says in any manner whatsoever find themselves in the hands of a party to the conflict.
That's an interesting question. What do the others think? I haven't thought about that. What do you think, Dean?
Well, I was just thinking, it's kind of like a little bit of a legal loophole. I mean, if you're fighting against a country, and a civilian of that country decides, you know what, I want to live in Australia, and they try and get to Australia and they get intercepted halfway, then from what I read there in that 4th Geneva Convention, because Australia is involved in that conflict, assuming, of course, again, it meets all the criteria of an armed conflict that's international in nature, they would be protected.
Peter, what do you think?
I don't think that that would be the case, because of the process of how they got there.
Mm.
I think once they've left their country as a refugee, they then become a refugee, not basically a citizen of that country.
Mm.
They're a refugee and they're under the control of the United Nations Refugee Committee.
I would tend to agree with the view of Emma and Peter on this point, that when you speak of civilians as commonly protected under the Geneva Conventions that protect civilians during war, you don't speak of the civilians who flee a state and then happen at some point, let's say in the seas, to kind of engage with one of the warring states. I don't think that's the nature there, because the nature, because of the use of the word occupying, an occupying force, we would assume that there is some level of land-bound territory that is involved, and it is only therefore when, for example, you have an occupying state and they come across civilians that are not their own nationals, that international humanitarian law will apply to treat them, for example, humanely. Or it could be that in the process of a state trying to be in an armed conflict with another state, they then again come across civilians who are they're not their own nationals. But that is in the course of the armed conflict going on. So I wouldn't think it would apply to those instances that you gave the example of Dane. Okay, so we have the final question. So, okay, we're clear about this. So terrorists and local rebels have captured to be treated as prisoners of war. The answer is no. Terrorists, no. Local rebels, it depends. Okay, it depends. So does international humanitarian law apply to terrorists, such groups such as Al-Qaeda, ISIS, or ISIL? The answer is no. Okay, so those are the questions I have. Any questions or comments before we end tonight's tutorial? Anything that wasn't too clear?
When you said local rebels, that depends. It just got me thinking. That's why states are very quick. Would I be correct in assuming that's why states are very quick in trying to label local rebels as terrorists?
That's right. That's true. That's right. So from Ainsley, can I confirm the quiz answer was B, New Kenya? So the correct answer, Ainsley, you're right. The correct answer is New Kenya is not in breach of international humanitarian law. As to the letter, though, we need to remember that as far as the quiz is designed, the answers are shuffled. So don't rely on the letter, but rely on the correct answer, which is New Kenya is not in breach of international humanitarian law. So we're good. So thank you, everyone, and I hope to see you again next week. Good night.
Thanks, Manjo.
Bye.
Good night.